right, welcome back. Shh. I'm grateful there were several of you who were in class yesterday, a bunch of you. If you haven't watched the video, it's on YouTube. When you watch it, just email me. I will mark you present. Do it, please, within a week from yesterday, so by next Wednesday. I will appreciate it. A note, there's no class on Tuesday. It's a holiday of Rosh Hashanah. If any of you are celebrating, have a sweet new year. Thank you. Otherwise, I will see you on Thursday for next week. We do have class today. You happy? Yeah.
I said the
Thank you, thank you. I actually had a student a couple of years ago who said he never had a professor who canceled a class for a Jewish holiday. It was the first time, so I was happy to do that for him. Okay. Any questions on the nuisance class? I realize some of you haven't watched the video yet. If you watch it today or tomorrow, I have a question, you can come talk to me. But if anyone has any questions now, please tell me on nuisance. No questions on nuisance? Okay. Let's move on to our topic for today, which is easements. And I'd like to start you off with a poll question, please. And it's a straightforward question, true or false. The question is this. Just be here on time, please. Late is late. Let me tell you a story. I read about this recently. There was a court, I think it was in Texas, but not certain, but there was a court where they were calling cases for trial. And the way it works, you sit there, you wait for the judge to call your case for trial. If you're not there when the judge called your case for trial, your case is dismissed. A lawyer went to the bathroom. And while the lawyer's in the bathroom, they called the case for trial. Wasn't there, case was dismissed. I don't think law students quite appreciate that aspect of our profession. If you are not present when the proceeding begins, you default, you lose. Your client will sue you for malpractice, right? If you have to go to the bathroom during a jury trial and you get up and go, the side can move for mistrial, right? They can move to dismiss the case because you're not there. Your client can sue you. Law students don't quite get this. It's really important to be on time. It's not because I'm being a hard ass, right? I always start on time and finish on time, but if you're not here in your next job after you finish law school, you lose the case, right? Your client will sue you. If you submit a brief to a court 1 minute late, they don't accept it. In most cases, statutes of limitation are jurisdictional. So 12:01 is not 12, right? Midnight is not 11:59. You have to submit it on time. And if you blow a statute of limitation, it matters. Right? I had one case where we filed it one day before the statute, and we got it in just in time. It was a hustle to get there. We got it in time, and then we got it. But if 1 day late, then you lose your case. So don't make this thing as like Josh is being a bit hard on you. I am trying as best as I can to replicate what you're going to have to deal with when you get forward, right? You're going to have a judge, you're going to be sitting here, you're going to have a boss, whatever it is, but you have to be late. The other thing that law students don't quite get is keeping your own attendance. Now, this app makes it easier, right? I actually love this app because you can look at your phone and say, oh, I have 1 attendance, I have 2 attendance or absences, right? But I used to have the pass-around sheet, right, where it would pass around. Oh, come on. You got to be on time.
Sorry.
Yeah. You missed my guilt trip, and now you're going to have to watch it again later. But I used to have people pass around the attendance sheet, and I always get an email, how many absences do I have? You should keep your own attendance records for class. You should know what classes you've missed. It shouldn't be our responsibility. I'll give you an easy example. When you graduate, you're going to have continuing education credits, CLE. Right? Every lawyer needs about 15 hours a year of continuing credits. You keep those records yourself. You don't have to check with the teacher. So this is your responsibility. Now, in my morning class, my 9 a.m. class, I have a policy, which I do for 9 a.m. classes. If you're not in your seat at 9 a.m., you're absent. 9:01 means you're absent. It's not a fun policy to enforce. I don't need to do that in the afternoon, because I think you're all here, but if I sense you're starting to come in late, then I'll impose that policy. I don't like doing it. It's not fun, but you need to be here when class starts, not coming in, taking your laptop out, moving your book when people are trying to study. So I got that out of the way, but please keep in time. Okay. All right, let's do the question. The question is this. Can a person pay to trespass onto someone else's land. Can a person pay to trespass onto someone else's land? True or false? I gave you plenty of time, but another 10 seconds. We had a little bit of an interruption. Okay, very good. I'm going to stop it there. All right, where am I? Okay, I appreciate. That means Zach's next? Or you're next?
No, I'm next.
Okay, well, okay. So Matt, I'll call on you. Oh, Matt, then Zach. Okay, so Matt, what do you think the answer is here?
I'd say false.
Okay, why do you say false?
Because if you pay, it's no longer a trespass.
Bingo. Exactly right. Perfect answer. The answer here is false. Most of you got this one wrong. Wow. The key, yeah, good job. The key word in this sentence is trespass, right? You learn this in torts, right? Property 1. What's a trespass, though, Zach? How do you define trespass?
Trespass is, I guess, entering on someone's property without permission.
The last part's most important, without permission. Zach, what do you call it if I enter a piece of property with permission? What do you call that? You're invitee, yeah, you're invited. Also, you can have a license, which is what we call it later today's reading, right? The very nature of a trespass is entering another property without permission. That's black letter 1L, right? So the answer to this question is false. A lot of kids get tripped up on this one. Because if you're paying, you got permission. It's not trespassing. The topic we begin today is what's broadly called servitudes. Servitudes. I don't like that word because it doesn't convey how it's used today. I like the alternate title, private land use controls. That's how the book titles chapter 10. I prefer private land use controls. But you're going to see the word servitude. You'll see it on the bar. You'll see it in other places. So you have to know that this is sort of another way of saying it, right? Private land use controls is when property owners allow someone else to control the use of their land, right? Historically, it's my castle, it's my home. I can do with it as I wish, right? And so long as I'm not bothering someone else, my castle, I can do whatever I want. With servitudes, with private land controls, you're allowing someone else to burden your property, right? Person A is letting person B burden their property, right? And that transaction is reached by virtue of a servitude, right? The servitude actually describes a sort of relationship between black acre and white acre that allows those sorts of burdens to be imposed. All right, so again, when I say a servitude, it's this broad category that describes different relationships of property A burdening property B, and maybe property B also burdens A. It can go both ways, right? Private land use is different than public land use. The next topic, maybe in 2 or 3 weeks, we'll do public land use. Public land use is like zoning, right? Where the city says you can't have residential in this area, or you can only have industrial in this area. Private land use might be what we call takings, where you have to give up some of your land to the government for public use, right? That's private. The current topic, servitude, is all private. Okay, it's all between individuals. The government is not involved. Everyone understand that point? What we're doing here is not government. It's owner of black acre, owner of white acre. They reach a deal. How do they burden each other's lands? Everyone with me so far? Okay. There are 2 major kinds of servitudes. And I say major because there are a lot of minor ones I don't care about. They're in the book. I'll mention them, but I don't really care about them. But there are 2 major kinds of servitudes. Now, these were not developed at once, right? The government didn't say, OK, let's have 2 different servitudes. Let's just make these 2 up. These 2 categories developed over the course of many, many, many years in England. And they developed as feudalism, right? The idea that you had these landlords who owned the land, the people worked on the land, right? These servitudes developed over the course of a long time. So the first servitude I want to talk about is called an easement. That's our first topic. And the second servitude I want to talk about, this is probably for next week, is what's called a covenant, or maybe even the week after. Okay? So the first one is easements, the second one's covenants. They're both tricky, right? They're both tricky. And I want to break down covenant a little bit more. There are going to be two kinds of covenants that we'll talk about. The first one is what's called a real covenant, right? And the second one is called an equitable servitude. Okay? A real covenant and equitable servitude. We will say those later, but I want you to just understand they're different kinds, right? Real covenants are enforceable at law, which means they're enforceable in courts of law. Equitable servitudes are enforceable in courts of equity. Okay? This won't make a lot of sense, but I want this to be in your notes. These are the major kinds of servitudes that exist. Major kinds. We'll spend, I think, 3 weeks on this topic. It's a lot of material, but this will just be like an overview for your notes so you know where we're headed. Make sense? Okay. There are two minor servitudes, which I don't think I'll ever mention again. One is called a profit. It's like obscure. It's like the right to take lumber, right? Yeah, who the hell cares, right? It's you have a forest that someone owns, and then you're allowed to take wood, lumber, chop down trees. Okay, yeah, whatever. Yeah.
Would that also be like people are allowed to take like vegetables?
Kind of, yeah. Taking vegetables is actually more complicated. There's a lot of. Let me put it this way: almost anything that a prophet can do, you can do with a covenant, right? You can do a covenant for just about anything. So you don't need to these more obscure ones, if that makes sense. So the prophet was just this kind of unique thing for lumber, which I don't know why, but that's history. The second one that's kind of minor is called a license, which we'll talk about today. A license can be oral, right? Oral permission to enter land. But we'll learn one of the restrictions on a license and oral licenses is that they're not written. Statute of fraud kicks in, and therefore how much they're enforced is very tricky. In other words, you can't bind a next generation, so to speak, based on a oral license. You can only do it based on something in writing. So the licenses don't play too much of a role, but they come up in the cases, and we'll do one, the Kentucky case later today, Holbrook. Okay. Everyone with me? All right. So just keep these sort of major categories in mind. Okay, so let's start with easements. One of the most important inventions in the history of land use was the fence. I know it sounds stupid, right? Why wouldn't you have a fence? Well, think about it. Back in the olden days, there was a lot of land and not many people. You didn't really need your own piece of land. You were sort of a hunter-gatherer. You moved around. You were nomadic. You went from place to place to place. But as English law developed feudalism, your manor, your blackacre became very important. And if you had a farm, you didn't want someone bringing their cows onto your farm to graze on your crops, right? So people started building fences. It's an old idea, but this started happening. But there's a problem. Let's say that you build a fence, and that blocks your access to a body of water. Right? Let's say there was a river which had fresh water, and you used to go to that river to get water. Now there's a fence blocking it. The guy who owns Blackacre says, "Sorry, I have a fence there." And you say, "Well, I really need to get to that water." And he's like, "Well, sorry, it's mine." So you say, "Well, I'll make you a deal. You give me access to the river and I'll give you access to my pastures where you can graze your animals. Seems like reasonable, right? Animals need grass, they need water, right? So they make a deal, right? The owner of property says, okay, I'll give you access to my pastures if you give me access to your river. Okay, that sounds great. And then for however many years, they sort of go back and forth. And then the owner of one of the pieces of land dies, and his son inherits the property. And the son says, okay, I want to go there. I want to bring my, I want to go there get some water. He's like, nope, sorry, I had to deal with your dad. Okay, you can't graze here. Oh man, right? So the problem became very clear that when you had these sorts of arrangements, they couldn't just be limited to party A and party B. What actually happened is that the benefits and the burdens attached not to the individuals, but to the land, to the property itself. So that whoever was residing on Blackacre would get the benefit, and whoever was residing on Whiteacre would have the burden, right? And these benefits and burdens would go from owner to owner to owner. There's an expression we use in property. We say it runs with the land. You'll hear this a lot. You'll see it in the book. It runs with the land. That means it doesn't limit to the current parties, that Blackacre will be here for 100 years. There will always be a river there. And whoever owns Blackacre is burdened by having this people come on to take the river, take the water. Everyone with me? Everyone understand that point? It's a little tricky, but so far so good. Okay. This kind of an easement that I just described is called an easement appurtenant. Okay? An easement appurtenant. Appurtenant's a funny word, right? But the key part of this word is tenant, right? What's a tenant? The tenant is a person who resides in a piece of land. So the way I remember it, and you can do the same, when you think of the tenant, it's whoever's residing on the land, right? Not the person themselves, but whoever's residing on it. Not Josh, not Bill, but the owner of Blackacre. The concept of an easement appurtenant suggests that whoever owns the land is bound by it. Okay? Everyone with me? The concept of an easement appurtenant is that whoever owns the land has the burden. What did I say? I said something wrong? Did I mumble? I'm sorry. I do that sometimes. I'm sorry. Okay. That's an easement appurtenant. The other one I'll get to in a few minutes, but I want your notes to be complete, is called an easement in gross. Right? The easement in gross is where the benefit or the burden applies to an individual, not the land. So it applies just to Josh, and if Josh leaves Blackacre, then the benefit travels with Josh. It doesn't stay on Blackacre. But I'll get to the gross one in a minute. I want to focus on easement appurtenants first because they're a little bit more difficult. Okay. I apologize. I'm lecturing a bit, but this is a little bit tricky. I want to make sure you got your notes as clean as possible. All right. So let's talk about easement appurtenants for a little bit. Okay. I always spell that word wrong. I got it right twice through. I'm very happy. Okay. So let's use an example, right? I'll be very creative. There are two pieces of land. First one is called wet acre. Second one is called dry acre. Original, right? Wet acre has water. Dry acre does not have water. This is easy as I can make it. All right? And let's just say that A owns wet acre, and that A owns dry acre, right? He owns both of these plots of land. Sounds reasonable, okay? And let's say that A sells dry acre to B. I'm sorry, I messed up. Let's say A sells wet acre to B. Sorry, I said the wrong one. So A sells wet acre to B. Everyone get the setup, right? A owns both pieces of land. He owns wet acre and dry acre. But A decides to sell wet acre to B. Now, is that Tyler?
Yep.
Tyler, what might A want to do if he's smart? Because he's selling the land with the water on it, and he's stuck on this parched land without water. What might A want to do here?
Reserve a right to continue using the water.
Very good, right? So when A sells wet acre to B, he retains an easement to enter wet acre, right? I say this again. When A sells wet acre to B, he retains an easement. Now, what does that actually mean? Think back to property one with a bundle of sticks, right? We think of property as sort of bundle of rights. A did not give fee simple to B. He did not give the entire stick, the entire bundle of sticks. When A sold wet acre to B, he took one stick out of the bundle, which was the easement, which means he can now cross onto wet acre to get water without being accused of trespass. Right? That's what an easement allows you to do. It allows you to enter a piece of property which someone else owns, but you have permission to do so. Right? The entire notion of the easement is you can now cross onto wet acre. 1 second, Stephen. But you do this at the time of the transaction, right? When A sells wet acre to B, he basically says, here, I'm giving you everything, the entire bundle, except for the right to cross onto it. So now if A crosses to wet acre, he cannot be arrested for trespass because he has an easement to do so.
Would this typically be, when you say access to water, like a well or a pipe or something?
I said river, but it can be whatever you want. Might be a lake, might be a river, whatever it is. You can craft the easement that says you have access to the river at certain times of the day, right? You can take so many gallons a month. You can specify it however you want, but this is an easy way of saying you can cross over and take the water. Rivers are easier because there's no plumbing involved. It's just sort of natural. Or a lake maybe, which is a freshwater lake. Okay, everyone with me? Okay. Now, B has a choice, right? B has a choice. How are they going to structure this transaction? Because B is saying, look, I'm going to have a trespasser. Not in name, but someone coming onto my land. So B can say, look, I don't really care. I am a good citizen, and I don't mind anyone coming onto my property, whether it's A or someone else, right? What happens if A sells dry acre to someone else? Then the owner of dry acre comes on board. C, right? So maybe B says, I'm okay with anyone coming on board, right? I don't care. Whoever owns dry acre can come to my land. We call that an easement appurtenant. Why? Because the benefit is linked to the owner of dry acre. Whoever happens to own dry acre can now use this easement. So if A sells it to C, and C sells to D, and D sells to E, whoever the current owner is can now use the benefit of the water. Okay? That would be an easement appurtenant, right? In other words, the owner of dry acre can enter onto wet acre, whoever it happens to be. That would be an easement appurtenant. But maybe B doesn't like that option. Maybe B says, look, I'm okay with you, A, but I don't know who's going to be here down the road. I'm giving you the benefit. Only you the benefit. Okay? So let's say we have another option, option 2. A sells wet acre to B, but retains an easement in gross to enter wet acre. Okay. Alyssa, who now benefits with this second hypothetical? A and only? What if A sells wet acre? Yes. So now A can enter onto wet acre, not the owner of dry acre. So if dry acre is sold, is conveyed, A is stuck. Now, someone's going to ask me, can you transfer an easement in gross, or can you inherit it? The answer is complicated. We'll get there a little bit later in this term. But generally, they're hard to convey, right? This is going to be a benefit for basically the sole benefit of A. And when A dies, it can probably be inherited to his heirs. But they're very hard to convey inter vivos. And I don't want to go too into depth now because it gets messy. But that's the short answer. Someone always asks that question. I'm like, later, come back to it. So you can do easement in gross or easement appurtenant. And depending how you write the easement, different people get the benefit. Yes, sir, John.
Sorry, were you saying that it's likely inheritable but difficult to convey, like a transfer when
We're going to do a case on this, I think, next class. I don't want to jump the gun too much, but the rules are complicated about conveying easements in gross. So I don't want to. If I get ahead of myself, you'll confuse you. I don't want to do that yet. So that's my short answer. I told you someone would ask, and they do. No, I mean, because it's a logical inference, right? Your mind just wanders, so to speak. Okay. Okay, so that's the difference between an easement in gross and an easement appurtenant. The law favors easements appurtenant. The law favors easement appurtenants. What does that mean? If you have an instrument that's kind of vague, and the courts, aren't really sure which one it's going to be, they will prefer to interpret it as an easement appurtenant. Why? They're easier to apply, right? Whoever owns whoever owns dry acre gets to go into wet acre. That's easy, right? Whoever the current owner is gets this benefit. It's stable. It's predictable. If you buy a dry acre, you know you're getting this benefit. But with the easements in gross, it involves laws of heredity, which is why it gets complicated, where you now have multiple heirs laying claim to the right to cross into a piece of land that they may never actually use. They may not even live there. So the easement in gross is not very useful. It doesn't apply well. So the courts prefer the easements appurtenant. Yes, Stephen?
Two questions to the easement in gross. Are they tied only to the person who owns, like, okay, so B owns dry acre, or A owns dry acre, sorry. Are they only tied to A so that if B dies and someone else gets wet acre, A still has the access to wet acre?
Yes. Okay, and actually, I'm going to answer your question in a minute. I'll get there in 2 minutes, but the short answer is yes.
Okay, and then also, are they revocable? So if he no longer
An
likes
easement can only be revoked if both parties decide to revoke it. They can release it. But let me explain another point. There are two terms that I need you guys to learn. Dominant tenant. How do I say that wrong? Dominant tenement and servient tenement. Okay? I'll write them out because it's a tongue twister. Dominant tenement and servient tenement. Dominant tenement and servient tenement. Okay, they're tongue twisters, but you'll have to say them at some point this semester. Okay. When you have an easement, there's one property that's giving the benefit, and there's one property that's getting the benefit. Or to say it differently, one property is burdened, and the other property is benefited. Okay? So we have wet acre and dry acre, right? Which one's being, is that Jennifer? Jennifer, wet acre and dry acre, which one is being burdened?
Wet acre.
Okay, very good. Which one's being benefited?
Dry acre.
Very good. Okay, so wet acre is being burdened, And dry acre is being benefited, right? Why? Because their water exists on wet acre, and all these people coming over and taking their water. That's why it's being burdened. Dry acre is getting the benefit because the owner of dry acre can come on and take the water. He's getting the benefit. Everyone with me? Now, wouldn't it be easy if we just use word burden and benefit? Wouldn't that just be really simple, right? No, property, right? You got to use big words. So instead of using the words a burden and benefit, we use the word dominant and tenement. So the dominant tenement is the one that's being benefited, right? Which in this case is dry acre. And the servient tenement is the one that's being burdened, which in this case is wet acre. Okay? The dominant tenement is the one that's being benefited, which here is dry acre, because it's getting the benefit of the water. And the servient tenement is the one that's being burdened, wet acre. Everyone with me? When you have an easement question, you should always put in your head, okay, Josh, which one is dominant and which one's servient? And the way I remember it, servient is like serving, right? The one that's serving is the one that's doing the burden, right? And dominant, the big, powerful one, that's one's getting the benefit. That's how I remember it, whatever works for you, but just you have to keep them straight in your head, right? Now, the way I will confuse you about this on the exam, and I'm warning you so it's not a trick, is they'll be reciprocal, right? Well, A will burden B, and B will burden A. So let's say that one piece of land has water, and the other piece of land has a field for crops to grow. A can cross onto B, and B can cross onto A. So that a land can be simultaneously both servient and dominant. Oh, damn it. A land can be simultaneously both servient and dominant. Everyone understand what I just said, right? Black acre can be both servient and dominant at the same time, right? It's servient in the fact that it's being burdened, but it's also dominant because it's receiving a burden. So don't only think in a question as only one. So if I ask you, what is the dominant estate here, there might be two, there might be three, right? I can ask it lots of different ways. And that's one way that these questions can get kind of tricky. Yes, sir, Andrew?
So it wouldn't be two separate easements, one where you got the right to go onto dry acre for feeding your cows, and then one where you've got a right to go on the water. Would be a single easement?
It can be done in different ways. So, let me take Andrew's question, because I think it's a good question, right? Let's say that A owns black acre and white acre. Okay? Simultaneously, right? A sells black acre to A with a benefit to burden owner of white acre. And I'm sorry, that should be A, it should be B. I'm sorry. And this is more or less your question. And then A at the same time sells white acre to C with a benefit to the owner of black acre. Sorry, I wrote benefit and burden. All right, so this is basically your question, right? In the same transaction, you have A who basically sells both of his plots of land. And he gives A one plot with an easement and B another plot with an easement, which benefits each other. So in the same instrument, the same document, you can sell both of them and have reciprocal easements. Everyone sees what Andrew just asked, right? You can do it in multiple transactions, and I think the California case sort of gets at why that's a little problematic. But the most easiest way is you got one person who owns a lot of land. He says, okay, you get black acre with an easement, and you get white acre with an easement, reciprocal. You both have it. And in this case, both black acre and white acre are both servient and dominant at the same time, simultaneously, right? Because they both benefit and burden each other. Okay. In any question which has an easement appurtenant, you need to be able to identify both the dominant and servient tenements. Right? In any question where I give you where it's an easement appurtenant, you have to be able to identify both the dominant and the servient tenements. Are we done? Back to Zeke? Oh no! Oh, Andrew, sorry. You almost. Almost snuck by, right? So I said with an easement appurtenant, there's always a dominant and servient tenement. What about with an easement in gross? With an easement in gross, is there a servient tenement?
Yes.
Oh. Yeah. So let's go back over here, right? Our second example. Oh, by the way, to make it even more confusing, you see both dominant tenement and dominant estate. You see them both ways. I will say tenement because estate has other meanings and it confuses people. But you'll see in cases dominant estate, dominant tenement. They're the same thing, but unfortunately different words. I don't like saying estate because it makes you think of future interest, all other garbage, right? So I say tenement, but you can, you'll see it both ways. It's not garbage, but it confuses you. All right, so Andrew, back to you. With an easement in gross, let's go back to our example over here. All right, we have wet acre and dry acre. What's the servient estate here, Andrew, with this hypothetical?
Wet acre would be the service.
Okay, why?
Because that's the property being burdened.
Very good. Now, in this second hypothetical, Andrew, is there a dominant estate?
I guess it's a person, but
You're right.
yeah.
So what's the answer? Is there a dominant estate?
Yes. No.
No. Tell me why the answer is no, Andrew.
Because it's a person on the state.
That's key. With an easement in gross, the benefit does not go to land. It goes to a person. And a person is not an estate. A person is not a tenement. So with easement in gross, there is no dominant estate. I say that one more time. When you have an easement in gross, there's no dominant estate. I can trip you up on the exam. I can ask you to identify all the dominant and servient estates in a question. And if it's in gross, there are none. There are no dominants. And then you get that wrong. I trick you. It's not a trick 'cause I'm warning you like a month in advance, right? But I'm telling you, you have to be able to distinguish the easements appurtenant from the easements in gross, because otherwise you get other stuff wrong, right? This is just the first level we're talking about. If you can't get the easement correct, the entire thing falls apart, right? If you can't identify the correct servitude, you get stuff wrong below it, right? Remember I said at the start you have easements, covenants, this, that. There are different rules for each of these. And you have to identify the correct servitude at the outset to know what rules apply. If I give you facts describing an equitable servitude and you apply the rules for an easement, you're wrong. I promise you at least 20% of you will do that in the exam, right? I will give you an easement and you'll give me the rules for covenants. Or I'll give you a covenant and you'll give me the rules for an easement. Or I'll give you an easement appurtenant and you give me the rules for easement and gross. It's like predictable. I know it's going to happen. I warn you, you're going to do it anyway. But okay. All right. Any questions so far? No? Okay, we'll move on. The next half of the class is actually a little bit easier. The two cases aren't terribly hard. The first, I think the most significant part of this class was the first 40 minutes or so. Everything after this gets a little bit, I think, simpler. Okay, now we're down to Zeke. So Zeke, how would one create an easement?
I guess they're in the when they transfer property, they write it in the.
Okay, so that's the important point is writing, right? The statute of frauds, our favorite, never goes away, my friends. The statute of frauds applies to easements. You cannot have an easement in oral form. There are exceptions, which is a license. Jacqueline, remind us, what's a license?
A license is an allowance of when somebody's given permission to commit.
And how is it conveyed?
Orally.
Orally, very good, thank you. The key distinction between a license and an easement is it's oral. Licenses are spoken. They're effective, right? You can do an oral license, but they don't satisfy the statute of frauds. You can't inherit a license. You can't transfer a license. You can transfer easements. Okay? There are two exceptions which we already mentioned the first day of class. Actually, Tyler, you asked me this question after class last week. what's prescription?
So something that's utilized for such a period of time that there's reliance or it's customary that access is permanently granted.
Yeah. Prescription is like adverse possession for easements, right? Prescription is like adverse possession for easements. So remember the first week of class we had the von Balkenburg case from New York. And you had the guy who crossed over the lot every single day for like 30 years. And the lawyer said, aha, he obtained prescription. What that means is by crossing over, you actually obtain an easement. If I walk across a field every day for a decade, I don't own the field in fee simple. What I merely get is an easement to cross it. And we call that an easement by prescription. It's not like with medicine, like the same word, like you have a prescription for pills, right? An easement by damn it, spelled it wrong. An easement by prescription, right? It works in a similar fashion of adverse possession. The same factors. It's to be open, notorious, continuous. You have to have the state of mind. The same factors that apply to adverse possession apply to prescription. This is why I mentioned Rockefeller Center every year closes down for a day to block any prescription claims, right? You can't say it was continuous because you didn't cross it one day. Yeah.
Would that be engrossed?
Yes. You don't really call it that, but it's effectively for your benefit alone, right? Doesn't because there's no dominant state at all. It's just for your benefit. Yeah, but I think it would have to be engrossed. I think so. Yeah. One note, talking a lot about exam today, I can trip you up in an exam, right? I can give you a question about prescription and you talk about adverse possession, right? They often might look a lot alike. And you'll need to distinguish whether I'm talking about prescription, which is for an easement, versus adverse possession, where you get the entire fee simple, the entire lot. Yes, sir?
If you have an easement, either in gross or by prescription, can you give an oral license to somebody else to do something on your behalf to enter, like retrieve water or?
I think so. Yeah, I think so. If you have a prescription that's legit, you have it, you can then get some of the right to basically your agent to use your easement for you. I think that would be permissible. I think so. Okay, so again, prescription is another way of creating an easement without writing. Usually you need a writing, but if you have a prescription, you don't need a writing. The second one is kind of weird, and we'll talk about it in the next class or maybe the class after, which is called an easement by implication. Oh, I spelled both those words wrong. Wow. Easement by implication. These are kind of weird, right? I'll give you an easy example that never comes up, but it happens. Let's say you buy a piece of land that's landlocked, right? You own this lot in the middle, and then there's land surrounding you on all four sides, and you can't get to a road, right? Josh, why would anyone be dumb enough to buy that land? People do it, right? They don't know what they're doing, right? They make a mistake. So again, you have this lot in the middle. Think of a donut hole, right? You're in the middle, and then you're completely surrounded on all sides. The courts will actually imply an easement, saying, okay, it's not fair to keep Josh landlocked. We will force you to give an easement on Blackacre next door. You got to pay for it, but it's forced. It's not like optional. We'll do cases like that, but just keep that in your notes for how it works, because you don't always need a writing, right? The statute of fraud generally applies with the exception of prescription and implication. Sure. The courts will basically imply it. I mean, the courts say there is no easement in writing, but because there's some really necessary reason, we're going to make you give up an easement. When I say imply, I mean like the court orders you to do it. We'll do a case in this. It'll make more sense. But just think of a donut. You're in the middle. You're surrounded on all sides. The court says, you know what? You got to cross the land. Or, imagine you have a piece of land that's surrounded by mountains, and there's only one road out, and you have to trespass to get there. They'll give you a way to get to that one road. Or, there's another case. Let's say you need to build a sewage line, and the only way to get a pipe for sewage to a person's house is by trespassing someone else's land. The court will say, okay, we'll give an easement to trespass, put a pipe to get sewage. So there are different cases where the courts force property owners to give up land for an easement for someone else. Usually it's you can't access a road, but there's some weird cases we'll talk about. Everyone with me? Okay. 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 The next case is from California. And what are they going to do? Reverse the you don't have to read it, but you know exactly what they did. They reversed the common law. At common law, to convey an easement, it was kind of complicated, right? I couldn't just go over to Ernest and say, hey, Ernest, you own Blackacre? You want to give me an easement for Blackacre? You couldn't do that, right? You had to convey the piece of property with an easement attached to it, right? So I gave you this example before, kind of weird, like A sells wet acre and retains an easement. Why did I make it that sort of complicated deal? Because at common law, you could not convey an easement by itself. You couldn't just hand Ernest an easement. You can't do that. Instead, you would have to convey Blackacre with an easement attached to it, which requires a transaction. Now, what happens in California is they try to take a shortcut, and we'll see that ultimately work, but under common law, you couldn't do that. So again, for the exam, if I say you're in a common law jurisdiction, you can't follow the California case. You got to do it the old-fashioned way. All right, Ernest, you want to give me the facts, please, in our first case, Willard versus First Church of Christ Scientists, California, 1972?
Yeah, this case has to do with an easement where we're dealing with the common law versus the modern approach.
Good.
To how we get the easement. And the easement was, I guess, reserved for.
Well, let's just start again. What lots did McGugan own? Let's just start very basic.
Okay, you mean 19 and 20?
Okay, so McGugan owns, this is a picture you can use, lots 19 and 20. Okay, then what happens, Ernest?
Okay, and so there's, I mean, as you can see by the picture, there's no way for them to kind of, reach.
Well, what did, just let's start with the facts. You're giving me the analysis. Let's start with the facts, right? What was lot 20 used for? Initially, at least.
That was vacant.
Okay, but what was it used for?
Oh, parking during services.
Parking for what?
During services of the church.
Okay, very good. Thank you. Okay. So Miss McGugan owned these two lots. She owned lot 19 and she owned lot 20. Lot 20 was vacant. Vacant lots are very good for parking, right? So every, I guess, Sunday, whenever there were church services, they would come by and they would use this lot for parking. That's fine, right? If you own a piece of land and you let people on, it's fine. There's no adverse possession. There's no prescriptions with permission. Okay, so Stephen, what happens next?
They said that he recorded the deed, but there was no mention.
Whoa, who's he? So we start with McGugan. She owns lots 19 and 20. What happened next?
She sells the property to Willard.
Sells which one?
Lot 20, the parking lot.
No. No.
Willard expressed interest in purchasing both lots 19 and 20.
You're skipping a step. Calrain?
The lot of the office building.
Okay. Who'd you sell it to?
She sold it to Peterson.
Okay, good. Thank you. And then what happened?
She retained ownership in the parking lot, so she sold.
Okay, so McGugan only sold lot 19 to Peterson. Then what did Willard buy?
They also wished to purchase the parking lot, and Peterson agreed to sell both of the lots.
So what's the problem there, Caroline, right? So Peterson bought lot 19, and then Peterson sells to Willard lots 19 and 20. What's the issue here?
Peterson didn't.
He didn't own it. So he's a crook, right? I tell you, in all of my questions are crooks, right? When someone conveys a piece of property, you should just assume they don't own it, right? Unless there's some proof otherwise. So here we have a case where McGugan owns lot 19, and she's fine. Okay, she sells lot 19. Peterson buys it. Then Willard comes along and says, hey, I want lots 19 and 20. I want to get a huge property next door to each other. Peterson gave Willard a deed in fee simple for lots 19 and 20. He did not own lot number 20. So then, Danny, what did Peterson do? He sort of panics at, uh-oh, what am I going to do?
So Peterson went back to McGugan and put an offer to actually purchase lot 20.
Right. Everything okay? He leaves early. Oh no, that's all right. I said out loud what I was thinking. That's not what I meant to say. You ever do that? We were saying, okay. I don't know. Weird attendance day today. I have no idea. Anyway, Danny, you're right. I don't know. Peterson goes to McGugan and tries to buy lot number 20, which he didn't own. Now, McGugan was willing to sell it, but with a condition. Emily, what was the condition on the sale?
The condition was that the church could continue using it for parking.
Okay. The condition was that the church could still keep using it on Sunday for parking. Now, did Willard know that, or did Willard have any idea about this condition?
Yes.
Willard was the guy who bought it before.
Oh. So it was in the provision, but it wasn't in the provision that was recorded in the deed.
Okay, very good. Willard did not have notice of this condition. Now, Peterson's a crook, right? We can all, I think, agree at least that much, right? He sold a piece of land he didn't own. He got it with this easement on it, this condition, and he didn't tell the guy about it who was buying it. So this guy's a crook. The church attorney put the deed that was subject to an easement, and the easement runs with the land so long as a property for whose benefit the easement is given is used for church purposes. Remember the so long as, right? Fee simple determinable, but it's like this for an easement, right? The easement is in existence for so long as the land is used for church purposes. So in this case, just to make it clear, Kaylee, which one's dominant and which one's servient estate? Just use our terminology correctly.
So lot 19 would be the dominant and 20 would be the servient.
Well, actually, no.
Oh, you're talking about between the
Yeah.
church?
Yeah.
Oh, I'm sorry.
Yeah.
So the church would be the dominant and lot 20 would be the servient.
Okay.
Because the church is benefiting from lot 20.
Okay, very good. Thank you. The church is dominant and the lot 20 is servient. I think she's right. Okay, very good. Thank you.
Sorry.
All right, yes?
I'm sorry. So this is where I got hung up. I mean, the church being a legal entity, why is it not in growth?
Yeah. I would suggest that it's not a person. Now you're going to say, but a corporation is a person, which is probably correct. But historically, these easements were very commonly viewed as appurtenant because it's whoever happens to be running the church at that time would get the benefit. So it's not like the deacon of the church, if he moves, the easement disappears, as long as it's being used as a church. Now, if this is converted into a Catholic church or a Baptist church, something else, you're probably okay. What if it turns to a mosque or a synagogue, right? What if it turns into a religious charity home? Then you get to these issues of, does the current owner satisfy the condition? But it's not limited to one person. So I think it's better viewed as appurtenant than gross, but you're thinking the right way. I like what you're thinking. Okay. Anyway, so we have the situation where the deed that's recorded by Willard does not mention the easement for parking. Okay? Now, apparently Peterson told Willard that the church might want to use the land for parking, but it wasn't in writing. Sharissa, is that oral disclaimer sufficient? Is that okay? So between Peterson and Willard, what kind of action might exist? What would we call that? I'm sorry, no. Well no, I'm sorry, Sharissa, let me ask the question again. What do we call it when Peterson failed to disclose to Willard this easement existence in writing? What would we call that? You're thinking too hard. What, in general, what do I call it if I lie to you in a business transaction? Fraud, thank you, exactly, yeah. We have fraud, right? So without question, I think Willard could sue Peterson for fraud. I think that's an easy case. He lied, he did all this sort of side business, right? So there's no question. But Sharissa, this case isn't about fraud. What is this case about?
Like to the common law versus.
Well, specifically, what is Willard trying to do in this case?
Just trying to figure out if the lot is.
Does Willard want to? What does Willard want to do to this easement? Yeah, Willard is trying to argue that the easement's invalid, right? even if Willard prevails in his fraud suit, all he'll get are damages, right? Which I don't really care about. That's for torts. That's for another class. Maybe contracts, whatever else. That's not property. What matters here is the easement valid? Because if the easement's valid, you have to use the land for parking. And just think about this for a minute, right? If Blackacre is being used for parking, can you build on it? No, right? Because every Sunday, there can be a bunch of cars there. You can't construct anything. And once a student said, well, if you put up a billboard, okay, I guess it's a good idea. I guess you can maybe put billboards, I don't know, right? Maybe you build a parking lot that's for 6 days a week, I don't know, right? So maybe you can do some stuff. But they did not buy lot number 20 for that purpose. They bought it for some other business purposes. So the fraud action, though, is separate from whether you can cancel the easement. Now, Shannon, what are the grounds on which Willard seeks to cancel is the wrong word, but to have the court declare the easement invalid, right? What are the grounds to get rid of the easement?
He says that the grantors and the insurance and title people have all relied on this.
What's this?
They've relied on they've relied on the old rule that it has to be in the conveyance.
You're giving the right. What's the old rule? Just give me the old rule again.
The old rule is that to convey an easement, it has to be in the land transaction.
Very good. Very good. Okay. Right. So under the old rule, you have to do this little dance, right? It's what's called a straw man, which is kind of weird, right? So let me just walk you through how this would work. Okay? There's basically 3 steps. So we have lot 20. And the goal is to put an easement on lot 20 for the benefit of the church. Right? What the parties did here was a shortcut. They just said we're going to slap an easement on lot 20. You could not do that. Instead, it's a couple-step process. So first, what they would have had to do is convey lot 20 to some third party. Okay? And then that third party would convey lot 20 back with the easement on it. Right? You can't put the easement on it by yourself. You have to have the property conveyed somewhere else and then sold back to you with the easement on it, right? In other words, Mrs. McGugan couldn't do the easement by herself. You have to have a third party involved. Okay? Now, as a practical matter, this is risky, right? Why is it risky? When you convey Blackacre to some third party, it's theirs. They can just run away with it. It's like, screw you, it's mine. I own Blackacre. Now, you can find ways around it. You sell it to the secretary at your law office who sells it right back to you. Now, maybe your secretary goes rogue and steals it from you. Okay, that's fine. But as a general matter, you have these escrow firms, and that's what they would do. They'd be trusted third parties who would basically receive the property for the sole purpose of slapping an easement on it and selling it right back to you.
So the only way that you can put an easement on something is if your sole purpose is to transfer it back?
Let me say what you said a little bit differently. The only way to sell it was as part of a sale transaction, right? You couldn't simply put an easement on land in the abstract. You'd have to sell it without the easement and then get it back with the easement on it, right? It was it's really 3 steps, right? You sell it back with the easement on it. So there's 3 steps involved. You're looking at me funny.
It just, I guess from getting hung up is you're saying you can't sell something putting an easement on it for that person who sold it to.
But that would be a benefit for okay, so I see what you're saying. When you make the initial transaction, right, if you want that buyer to get the benefit, you could sell it with it on it. Here, the benefit was for a third party.
Oh.
Understand? Let me go back to my outline at the start of class, right? The example I used earlier. That's the very start of class. A sells Wetacre to B, but retains an easement to enter. That's fine. That's a 1-step process, right? Because it's A and B. But here the benefit is not for B, it's for a third party, it's for the church. In other words, the church is not involved in the transaction, right? The church is, oh God, sorry, go away. The church is not involved in the transaction, right? Because you have a third party involved, they need to do this two-step deal. Now, Matt, you seem to think this is kind of a stupid thing, this sort of multi-level arrangement.
Kind of, but I understand a little bit more now.
Okay.
Third party involvement.
Okay, everyone understand, right? Because there's a third party. Yeah, go ahead.
Well, I just had a question just building off that. So if it was the church's land at the beginning and they wanted to use it, they just kind of sell it straight to it?
Well, look, let's go back to our picture, right? Let's say the church owned lot 20. And let's say the church sold lot 20, reserving a benefit for themselves. They can do that. Right? But the problem is it's McGugan selling it to Peterson. Right? Peterson is not the church. So basically what has to happen is, what should have happened is, McGugan sold it to the church. Ready for this? And the church sold it to Peterson with the easement on it. Oh, now it crystallizes, right? So I was getting to. All right, so what would happen? McGugan sells the parking lot to the church, and the church sells it to Mr. Peterson with the easement on it. That way the two parties involved, the buyer and the seller, are on the easement. You need to do this additional step. What they did was a shortcut. McGugan sold the lot directly to Peterson with an easement for the benefit of the church, and that was a shortcut. I think that makes it a little bit more clear. Everyone see what I'm saying right now? Let me try in this picture, right? Had the lot 20 been sold to the church sells it back with the easement on it. It's this sort of back and forth two-step process. 3 steps, really. Everyone with me? Now, that was a common law rule. Andrew, what does the California court do with this common law rule? They always do. They overruled it. And why did the court overrule this common law rule?
Because it's antiquated.
Antiquated. What's that?
The need for that was based more on a reliance of the rule of Cezanne than it was
Season, yeah.
on
Yeah.
the rule of the law of deeds.
Yeah, I mean, the rule doesn't make a hell of a lot of sense, right? It adds a lot of complexity. It adds a lot of costs because you have to have 2 full closed transactions. It adds a lot of time. And what the court says is, let's get with the times, folks. Let's be modern, right? Let's be current. And we need to get rid of this old requirement that if McGugan wants to sell the lot number 20 to Peterson, she doesn't need to go through this sort of song and dance. So they've ruled the common law rule. Okay? So the modern rule is, I can just sell you Blackacre with an easement benefiting a third party. There's no problem. Now again, even under the common law, I can sell you Blackacre with a benefit for myself, right? If I retain a benefit for myself. But when you're benefiting a third party, you can't. That's why when I did this example at the start of class, I split it up, right? I split it up like this in 2 separate transactions. You started with A, and he sold it Blackacre with a benefit to this one, and Whitaker with a benefit to that one. You had these separate parties, right? You had the third party involved. But when you said 2 parties, you couldn't do it like this. Everyone with me? Now, a while ago, Shannon was talking about reliance, and I didn't want to, you were giving me a right answer, but it was like 5 minutes too early. What's the reliance discussion? I'll just come back, because you were like, yes, but not yet.
What was your question? Sorry.
Why? Willard says, how could you overrule the common law? I've relied on it, right? Imagine this, right? You're Willard's lawyer. Yeah, oh, good question, right? You're Willard's lawyer. Go to Jessica. You're Willard's lawyer. And you say, look, I've studied all the California cases. This easement is worthless, right? Because there was no third party. So what do you tell your client? What should he do? Should he honor the easement? Well, before this case is decided, right? Your client says to you, hey, I got this easement, and should I let these cars come onto my lot on Sunday? What do you tell him?
If they're following the old rule, then it wouldn't be valid. But
Okay. Okay, so Jessica, you argue this case at the California Supreme Court. You're all pressed. They look, Your Honor, here's the law. They say, yeah, never mind. We changed the law. Can you be sued for malpractice? Ooh. No. So I think you're safe, Jessica. Your license is not in jeopardy because you explain the law as it exists at the time you argue the case. And that's all you can do, right? If a court changes the law, that's not on you. But the better question, though, is, what about your poor client, right? He just litigated this case for years knowing that the law was on his side, and now he's out of luck. And Maria, let me ask you this question. What about everyone else in California who had, pending disputes involving this rule? What happened to them? I heard what you said.
I mean, they would get the same result.
They're screwed. They're out of luck, right? So there's a discussion about retroactivity. And this is a concept that you may not have considered before, right? But it's important. When a court makes a decision, they can do one of two things. They can say, number one, our decision applies to all claims everywhere. Or number two, they say our claim applies going forward, prospectively. The court here chose door number one, retroactive, which means any pending claim is now governed under this rule. Even if the deed or the deed was recorded at an earlier time than when the rule is otherwise. Right? Is that Andrew? Andrew, let me ask you, let me change the facts of this case a little bit, right? Here, Willard had no idea the stuff was going on, right? Willard just didn't know. Let's make the facts different. Let's say Willard found out. Willard found out that there was this deed that was conveyed to the benefit of the church, and he didn't really care. And he asks Jessica's lawyer, and Jessica says, oh, this deed's worthless. Easement's not worthless. And he goes forward with it. Can you do that? Could he have done that?
Yeah.
In other words, could he have bought the land knowing that there was a worthless easement on it that was unenforceable? But he could. Might maybe get for cheaper, right? In other words, one aspect of being a good lawyer is you tell your client, yeah, there's this risk, but it's not going to be effective, right? They think they have this easement, but go to court, you win. So you have all these people in California who were given legal advice, perhaps, saying, okay, here's the law. Don't worry about this easement. It's not worth the paper it's written on. And then court says, yes, it's enforceable. Okay.
So
Yes, Jessica, go ahead.
going back to, like, the whole accountability on the lawyer.
Yeah.
I mean, there were other cases where they kind of like circumvented the rule.
Oh,
Maybe,
what a
like,
good question.
Kind of like jobs, people,
Yeah.
and risks, and
So you see the law is maybe going in a different direction?
right.
Yeah, so I think Jessica is picking up on a very important point. If you're a lawyer in California, you should never trust the common law. I'm only being slightly facetious, right? But if you're a lawyer in New Jersey or California, you should tell your client, here's the law, but there's a good chance they'll reverse it. So take it with a grain of salt. Right? I mean, it's not a very good answer to have, but I think all lawyers have to be aware of that fact. I mean, my God, if you're a constitutional lawyer, oh, we have a new justice. Maybe we'll go the other way now, right? Things can change quickly, but it's a very good point. Yes, Stephen?
If you had a case pending in California court at this time and that case was decided, would you want to amend your pleadings or would your case just be resolved?
So what often happens is, let's say you're in the trial court and the state Supreme Court issues a decision. The trial court will basically ask the parties to submit new papers and maybe amend their pleadings or maybe settle the case. Because you can imagine, after this ruling, a lot of people have to settle their cases because they were going to lose. And there's no reason to get a judgment against you just to settle it out of court. But this is not a trivial concern. This is not just, look, I'm dumping on California, right? It's fun. But every state court can change direction, right? You can't always predict with certainty which directions courts will go. Stability is great. We love stability. We love, things being stable. But it's not always permanent. All right. Questions on the Willard case? Not that the facts weren't complicated, but to get the concept. Okay. The next cases are about licenses, and we already said that a license is oral, but it can also be written, right? You can give a license in writing. Now you might ask, Josh, what's the difference between a written license and a written easement, right? Laura, what's the big difference between writing a license and writing an easement? What's like the big difference? What's the key factor of a license that makes it sort of easier? Okay, good. But what if you put a license in writing? Why is that? If I give you a license in writing, I say, Laura, you can come over to my house on certain days for whatever, right? How's it different saying you can have an easement? Why is a license and an easement different in both in writing? Revocable, yes, ma'am, exactly. A license is revocable. You can say revocable or revocable. I don't care either way, but people say it both ways, right? Revocable or revocable, right? If I give you an easement, it's done. You're stuck with it forever, unless both parties, the dominant and the serving estate, sort of release it, which they can do. But with a license, it's revocable. But of course, there are exceptions. Aren't there always exceptions? There are always exceptions. And there are exceptions where a license may not be revocable. So for example, if there's certain types of estoppel interest, which is basically fairness, they may not revoke the license. If there might be some sort of interest where you've invested money in the land, there might not be revocable. So there are different ways in which the courts hold that even a license, which is in writing, cannot be revoked. Oral licenses are easy to revoke, but when they're writing, courts are much more favorable. Okay, Hannah, you want to please give me the facts in the next case, Halbrook versus Taylor?
So basically, they're trying to decide whether this right to the land is given by prescription or like whether they can enforce it by estoppel, like a slide.
Yeah, just start with the facts, please. Thank you.
So basically, they purchased some property and they gave permission for them to cut into the property so they could move coal.
Right, so basically, you have a road and they have to cut the side to make the road a bit wider. All right, go on, please.
And they were using the road until 1949 when the mine closed. And
Good.
During that time, they were paying a royalty for that use. And later on, about like 1957, they had actually built a house on that property.
Very good.
And when they were using that roadway, and then the house burned down in 1961, and they didn't replace it.
Good.
And then they built their residence, I believe, the year after. And all times prior to 1965, the use of that road was by permission of the estate.
Okay. Yeah, go on, almost done. Yeah, one more.
And then
What happened in 1970? Things started going downhill.
I think he bought it.
What happened in 1970? A very important act happened. Laura's illustrating with her hands.
He like covered the road.
What do you call that thing?
Uh,
I hear you. I hear you.
well, it was like spikes on the road.
Oh, you were guessing. A steel cable, right? They put a steel cable along the road. This is what something called a spite fence, S-P-I-T-E, not sprite, spite. A spite fence, where one party like puts up some sort of where one party puts up like a barrier to block entry to a road, and they put up a no trespassing sign. Now, the first thing you may want to ask about is Kyle is prescription, right? They've been using this land for years and years and years. Can they have obtained land by prescription?
Here, though, the lower court found that there wasn't prescription
Why?
because they had permission beyond the land that wasn't.
Bingo. Yeah, it's not hostile, exactly. There's no adversity. If you're using land with permission, you're what's called a licensee. A licensee. You're a permission. And therefore, you don't meet the elements of hostility for purposes of adverse possession. I'm sorry, for purposes of prescription. See, I did it myself. I confused the terms, but they're different. So that's right, Kyle. So they can't get through prescription. Andrew, so instead, what's the way that the court goes about finding if there's an easement to be had?
By way of estoppel.
Okay, so tell me, what is estoppel? What does estoppel mean in this context? But just more simple. What does estoppel mean? Just in the abstract. You've seen this word in a bunch of classes. What does estoppel mean?
Unconscionable to not allow it to continue.
Yeah, fairness, right? Estoppel is like a sort of a broad term that's used in legal decisions that when something's not fair, courts say, well, we'll intervene as a matter of equity, right? We'll intervene as a matter of fairness, right? So, Tony, let me ask you a question. What was the estoppel issue in this case, right? Why did the court find that that an easement was appropriate in this case?
Because petitioning party, they actually put in a bunch of work on it.
Yeah.
And up until they tried to get them to sign a certain document, they were allowed to use it.
So had there been any sort of written license?
No.
But what kind of license had there been? Wasn't it writing?
It was prescriptive or not.
You're thinking, what kind of license? It's not in writing, therefore it's... Yeah. It was an oral license, right? Yeah, you're overthinking, I know, right? So you had an oral license, right? And generally, oral license can't be revoked. But here, Grace, why did they find that this oral license could not be revoked? What was like the argument?
That it would burden these people who made these improvements, so by estoppel they weren't able to revoke the license.
Okay, very good. The court finds that an easement should be created by estoppel, right? That an easement should be created by estoppel. All right, what does that mean? The court creates it, right? The parties didn't negotiate for one, but because they found that this license should not be revoked, the court actually implied an easement, right? And the key factor, and this is something you'll see in a lot of cases, the key factor why estoppel was appropriate here was because they had invested money in the land, right? When you put money into land to improve it, you have an interest, you have a vested interest. And then it's not fair, my least favorite word in the English language, it's not fair to kick them out when they put money into it, right? So as a result of fairness, they said, look, they are now allowed to keep using this land. That's not costless, right? Because now the owner had fee simple, he no longer has it. And if he were to sell Blackacre to someone else, whoever he sells it to has to honor that easement. That easement is now running with the land, right? So whoever buys Blackacre can use it. Now, I'm not sure, someone's going to ask me, could that easement in gross be transferred? It's actually a complicated issue. I think here it couldn't. I think because of the circumstances, the easement was limited to this guy because he put the money into it. But at least so long as he's in business, he can use it. Now someone's going to ask, what about his business partner? Probably, but it gets a little messy. But as a general matter, Blackacre now has one stick out of the bundle taken away. It's not a fee simple anymore. Right? As a result, the license cannot be revoked, and there's basically an easement, at least for the life of the guy who built it, Holbrook. I'm sorry, Taylor. Okay, so in other words, this license cannot be revoked. It's basically you're implying an easement by necessity. I think it lasts for as long as the life of the for as long as the life of the tenant. Okay. All right. This case is some of an outlier. Not all cases come out this way. There's a short case afterwards from Oregon, Shepard versus Pervin, which says an oral license is just as irrevocable as a deed, and the courts enforce it. Right? And the next case is Henry versus Dalton. The court goes the other way. Right? Oral licenses are revocable. They can be canceled at any time. So the courts are sort of all over the place on this question. But at least you should understand that if estoppel to be had, it usually applies when there's some sort of money paid into the land. You have some sort of interest. Okay. Questions? All right. Again, there's no class on Tuesday. Have a wonderful, happy New Year. We will have class. One second, almost done. Don't pack up quite yet. I'm almost there. We will have class a week from today. We'll be talking more about easements. This involves easements by necessity and more easements by prescription. Anything else? All right, thank you so much. And please email me when you've watched the makeup. Thank you so much. Yes, sir.
So, you said that the primary factor was that the people who were using the license had invested